Good morning. Good morning. Good morning. I'm Leonard Baines, the Dean of the University of Houston Law Center. I have been Dean for 10 years. I'm the longest serving Dean in the great state of Texas. And I want to welcome you all here, students, alumni, and others, those at home or in your offices, and those in the room. And for those who may be new to the law school and the law center, this is taking place in our brand new, maybe not so brand new, John M. O'Quinn Law Building, $93 million, beautiful state-of-the-art building that was on the cover of Pre-Law magazine and was rated as one of the best law school buildings in the country. And we have really great students. I applaud the Law Review. This is the 29th Frankel lecture. They've always been incredible discussions, balanced discussions on really difficult issues. And today I'm really interested in learning about this whole thing about how people speak to each other. It'll be really, really great. And I welcome our panelists. And Professor Sleeve will go in more detail, but certainly welcome Professor Brooks, Professor McAdams, and Professor Norton. Thank you for being here. The law school students are amazing. Our median LSAT score is a 161, which is about 80th percentile, and the median GPA is 3.75 of our entering class. Our entering class was about 272 students, so it's fairly large, but really talented students from all backgrounds, from all over the world, all over the country. And our recent bar passage numbers were excellent. 91% passed the bar exam the first time. And in fact, one of the Law Review members, John Cabrani, scored in the top 3 on the test takers in the state of Texas. Let's give him a round of applause. And 95% of our students were employed 10 months after graduation. But the most important thing is really us coming together, and I really appreciate the Frankel lecture for doing that, for us coming together and discuss really difficult issues. That's the role of academia and legal academia, is to be a place where people can debate and discuss really important issues, where we provide, as I would say, light, not heat on an issue. And certainly these days, how we talk to each other, how we think about each other, are really, really important issues as we go forward. And I really appreciate the Law Review and the Frankel lecture for actually focusing on this topic this year, because it really is something that has been discussed, certainly among the judiciary, among lawyers and the bar associations, of how we can be more civil with each other. So thank you to Law Review and leadership, Sophia Winograd, for all her support, and everybody else who worked on this. And now I turn it over to my very esteemed colleague, Professor Peter Sleeve, who's going to do the welcome of our really esteemed faculty guests. So thank you so much.
All right, thank you, Dean Baines, and thank you to the Law Review for hosting this wonderful event. And thank you to all of you for being here. It is my pleasure to be the moderator for today's Frankel lecture and to introduce our very esteemed speakers. I will not be reading their entire list of accomplishments because I do want there to be time to do the lecture itself. But in very brief, in order of seating and also speech, we're very pleased to welcome first Professor Richard Brooks, who is the Emilie M. Bullowa Professor of Law at the NYU School of Law. His scholarship focuses on contracts and agency, business and social organizations, as well as the analysis of behavior through the lens of law, economics, and custom. He's written, among other things, on the law of racially restricted covenants and social norms, and he is our distinguished Frankel lecturer today, who will be speaking on addressing Americans, exploring how the words that we use to address each other influence our civil, political, and social lives. After Professor Brooks gives his comments, we'll have a response from Professor Richard McAdams. Professor McAdams is the Bernard D. Meltzer Professor of Law at the University of Chicago School of Law. He writes on criminal law and procedure, the expressive function of the law, statutory interpretation, law and literature, among other topics. He served as a member of the Natural Science Foundation Advisory Panel for Law and Social Science, on the editorial board of the Annual Review of Law and Social Science, has taught on several distinguished faculties before joining the University of Chicago. Last but certainly not least, we will have a response from Professor Helen Norton. Professor Norton is the University Distinguished Professor and Rothgerber Chair in Constitutional Law at the University of Colorado Boulder School of Law. She writes and teaches on, among other things, constitutional law, and especially the First Amendment and equal protection law, anti-discrimination law. Before entering academia, she served as the Deputy Assistant Attorney General for Civil Rights in the U.S. Department of Justice, that is, on President-elect Barack Obama's transition team, and as Director of Legal and Public Policy at the National Partnership for Women and Families. So please join me in welcoming our three distinguished speakers today. And without further ado, I will welcome Professor Brooks to the podium.
Good morning. Thank you, Dean Baines. Thank you, Professor Salib. I am honored to be here. I'm honored to be here at the Law Center, and I'm thrilled to be here in Houston. I heard this morning on NPR that there are now 4 barbecue restaurants in Houston that received the Michelin star this week. Not that Texans need a French Epicurean outfit telling them what's good barbecue, but that's good news. It's good news. I also want to express my appreciation to the Frankel Family Association for making this possible. I want to express my gratitude to Sophia Wingard and Madison Oswald and the Law Review for all the effort that they've already put into this. It's not easy wrangling 3 faculty with competing schedules to come, so thank you very much. And then finally, I want to express my appreciation to Professors Norton and McAdams, both for their serious engagement with the work. That's not something anyone ever can take for granted. Their critical and generous engagement. So I'm looking forward to hearing more and continuing the conversation with them. I'm going to sort of go a bit back and forth between reading comments to make sure I make my points explicitly and then maybe a bit more colloquially so I can actually look at you instead of looking down and communicate the ideas. It's kind of awkward writing or speaking about addressing people, but not really addressing them. So I'll try to address you. When I first got this invitation, I had just recently gotten back from Honolulu. I was working on a project with the Uniform Law Commission. I was the reporter for a new uniform law that was just promulgated at the annual meeting of the Uniform Law Commission in Honolulu. And I thought, this will be a good opportunity for me to talk about this topic, in part because it relates to work that I've been doing for a number of years, but also very much speaks to my view, my sort of, I don't think it's peculiar, but it's particular idea of what is law and what's the basis of law. And also, there was one law commissioner on the ULC from Houston who I had many, many conversations about this topic with. The topic was regarding covenants, servitudes, and property records. And of course, Houston is famous for the absence of zoning. And our many conversations focused on the ways in which covenants and other forms of servitudes really operate significantly to regulate land usage. Let me say a little bit about the kinds of covenants that I had, at least what the statute, which is now called, this is my advertising for it, the Uniform Unlawful Restrictions in Land Records Act. It's now been passed in 5 jurisdictions, Washington, D.C., Pennsylvania, Washington State, Arizona, and most recently Colorado, just this past May. And it looks like we're going to get Arizona next. So it's moving forward. And these are covenants that have been sort of long unenforceable. Let me say a little bit about zoning and about these covenants and these servitudes, and then how it relates to my general topic and what I want to talk to you about today. Because even though I'm not going to end up focusing on that, I'm going to talk, as the slide did say a moment ago, about the norms and the laws and the ways of Americans addressing each other. This does actually relate to it. So going back, Baltimore in 1910 passed the first racial zoning law in the country. It created a mechanism where if you sort of demark the city, majority black neighborhoods or white neighborhoods, and it didn't force anyone to move, because that would clearly be some kind of taking or too much of an overreach, but it did say when you sell your property, you have to sell to someone of the designated racial category. When you sell. And when you're buying, you can only buy into properties of that designated racial category. After Baltimore passed this law, it sort of spread all over the country. In 1917, a case comes up before the Supreme Court, Buchanan versus Wearley, and the Supreme Court says, no. Even though Baltimore kind of tried to place a dual restriction it was both that whites couldn't purchase into black neighborhoods and blacks couldn't purchase into white neighborhoods, satisfying the separate but equal Plessy versus Ferguson standard. Even though it did that, the fact that it was being done by a municipal organization, that created state action. So the state action doctrine prevented racial zoning at a very early state. I think if this hadn't happened, I imagine that the US probably would have evolved a kind of apartheid structure like South Africa, which is good and bad in some sense. It's bad in the sense that what followed, because you didn't need states and states couldn't do that, in a subsequent opinion in 1926, Corrigan v. Buckley, the Supreme Court affirmed that when private actors decide that they're not going to sell their property to persons of designated races, nationalities, religion, that's private and then those agreements are private, and when they subsequently get enforced, there's no state action. So no state action for private enforcement. And after this statement, racial restrictive covenants they were available before, but they take off. They just take off. The earliest ones I came across were against Chinese immigrants in California in the 1890s. But you'll find them in Washington State, peculiarly at first to me, prohibiting ownership and use of land by Hawaiians. And then as you move to the south, Arizona, New Mexico, prohibitions on Hispanics. And as you move further to the Midwest and the North, it was largely, there were some Irish, but almost every category of person you can imagine was excluded under these things. It's really just a panoply of exclusion based on characteristics of individuals, but they were significantly used against Jewish and African Americans. Interestingly, they weren't used in the South. It just really, well, let me put it this way. They may have been used somewhat in Texas, but if you look at southern states that had a majority of their black population before the Civil War, after the war, there was a lot of migration from the Old South into the New South, let's say. But if you look at and there they did have covenants, but not in the old ones, not in the, and what was operating there is I think people understood through social norms how to interact. What was going on in the other jurisdictions with these mass migrations of people, they hadn't really kind of interacted before. They didn't know the norms. They didn't know how to behave or treat each other. The NAACP and the Urban League, they would show up at train stations in Chicago with a little cards that they would hand out to people getting off the train. It's okay to sit next to somebody who's white. You can do this. Just people literally didn't know how to interact with each other. And it wasn't just the internal migration of blacks. Chicago at this time was in the, through the 40s, through the 30s, was majority foreign born. There was massive European immigration to the United States and the Europeans were coming, and Chicago is all balkanized. There's the Polish neighborhood, the Swedish neighborhood. It's just, they didn't know how to interact. They were new to America too. There was some interruption during World War I and World War II with this European migration that also fueled the Great Migration from the South, in part because of the wartime demands. So what's happening in a lot of these places, lots of new people are coming together, and they just don't know how to behave. They don't know how to behave with each other. What should we do? And then you get these things, these covenants, and they're really doing work. There's just lots of these private agreements saying that you cannot, you should not sell, rent, allow occupancy, use, and so on of these people of designated characteristics. Okay, I've got to move past. 1948, you guys all, you students who all know from your con law class that in Shelley versus Kramer, the US Supreme Court says, no, now when the Supreme Court enforces, or when courts enforce these racial restrictive covenants, that enforcement is state action. And that was an enforcement in equity. It was clarified later on in 1953 in Barrows v. Jackson that also you couldn't get money damages. So this is super interesting for me in how I think about law. So I think law is significantly about announcing one's obligations, recognizing duties, and it's not strictly about enforcement. It's not strictly about going to court or getting the police to enforce. I just think this is a view of law that's so very connected to Oliver Wendell Holmes's bad man theory, of course. But I don't think it's actually necessary or even that significant a part of our tradition. I teach all of the private law classes. I teach contracts, property, corporations, remedies. Section 1 of Restatement Second of Contracts defines a contract as a promise or a set of promises, for the breach of which the law provides a remedy, or and this is disjunctive, or the performance of which the law recognizes as a duty. You can have an agreement in the duty that's recognized in law, even absent effective remedies. Now there's some debate about that. Not everybody takes that, but that is my view. And here's something I thought that was just completely interesting. After these covenants become legally unenforceable, people continue writing them. They keep putting them in deeds. Why are they doing them? Why are they doing this if it has no function? Eventually, 20 years later, the Fair Housing Act makes it illegal now to create new covenants and to publish them, except for 3 units or more. But the people are still putting them in place. the Justice Department sends a cease and desist letter to all of the major title companies in the country in 1969, saying, you have to stop reporting these things. You have to stop reporting them. They haven't been constitutional to enforce since 1948. Moreover, the Fair Housing Act prohibits them. The ALTA commissioners, the American Land Title Association is the association, the principal association and a wonderful association, significant contributors to the uniform law that we worked on. They said, we're going to be on the hook. We're insuring these things. If for some reason that we don't report this and someone says that they are subject to liability, we're going to be on the hook. And because we're insuring it, we're going to continue to report it. And they start working with the Justice Department to do something about that. Okay, so here's the connection finally. There's something about the way in which these titles, these racial restrictive covenants, end up in the land record and how they become discovered. Let's say that you are a bank trying to decide, should I lend Brooks $80,000 to buy this property that's worth $100,000? They're going to do a title search. And that title search, the land title search, will reveal, at one point, either the developer in a deed or the members in the neighborhood together put in these racial restrictive covenants. I'm a bank, and I don't care about money. I'm in it for profit. If I lend Brooks $80,000 for a house that has collateral value of $100,000, I now know that people did not then, or maybe still do not want to be in that neighborhood with Brooks. There might be white flight, and in fact, there often was white flight. And when there is white flight, the neighborhood value drops. So the bank may say, well, we really should anticipate, or if not, there was also a tremendous amount of violence. All the insurance companies, they may say, we're going to insure this property. They're going to see this too. And as a consequence of that, they may lend less. The title itself and what it reveals, even though it is legally unenforceable, unconstitutional to enforce, both in equity and in law, actually has an effect because the enforcement of these announcements is not strictly through the courts, they're through all of these other legal institutions and social practices, like title recordation and search when you buy property. So that's just, when I started doing this, I didn't come in with a theory. When I saw it, I'm like, holy, wow, that's really what law is all about in some sense. It's about an announcement of one's entitlements and their privileges, whether or not they're enforceable. And remember, HLA Hart says not all laws are enacted. Not all laws are enacted. And most importantly, he said, this is true of custom. And this goes back to custom. We see it in the Deeks versus Crest. There's enforcement of discriminatory custom as well as non-discriminatory custom. A lot of law, our common law, was custom before it became the common law. And in particular, some very interesting work showing how we can think about much of the custom in our constitutional law too. So not all law is enacted. I would also say not all laws are enforced through courts and the police. They are enforced through other legal institutions like title searches, as well as social practices, and also law. So that's the broad overview, and now in the remaining 15 minutes that I have, let me tell you how it connects. So I started thinking about land titles, and then it occurred to me, well, there are titles to people, too. The title, professor, chief, not only titles to people, there are also titles that, like styles. Your Honor, honorifics, sir, ma'am. I love how traveling in the South. I love traveling in the South because these titles, they're just given so openly, generously. And there are some interesting theories about why. Right? There's you may have heard of this notion of the Southern culture of violence, that there was a time in the South, maybe still, maybe not, I don't know. There's some contemporary studies that also suggested that there's more violence, male, machismo, hostility, things that can just get out of hand really quickly. So one way of adapting to that risk of violence broadly is to have strong norms of civility. So there's no mistake. If somebody's insulting you, you know they're insulting you. There's no accidental affronts. And that's one way in which these patterns may evolve. I think there's something to that. I have the book project that I'm working on has many of these stories. But I don't want to talk about the stories. I want to see if I can drill down on the theory. And here, there are 5 things that I want to say. And I'll get them. See, I added 3 minutes. I have 11 minutes. 5 things I want to say. First, what is law? And that's quick. So I think law really is, it's about Mayor Dan Cohen, a really wonderful criminal law and legal theorist, scholar, has this great article called Acoustic Separation that he published in the Harvard Law Review in 1984. And Mayer says that when law speaks, it speaks to 2 parties. It speaks to those who are subject to the law. And it tells them what their duties are, what they should do, their conduct rules. This is what he calls it. And then law also speaks to legal officials. And it tells legal officials what they should do when people violate their conduct rules. He calls these decision rules. So speak to subjects of the law, conduct, what is your duty under the law? Decision rules to legal officials, what to do if people violate their duty. He said if there was an acoustic separation between these 2 forms of speech, subjects of the law, they would really get what their obligations are. I'm supposed to not drive over 25 in a school district. I'm not supposed to breach my contracts, keep my promises. I'm not supposed to harm intentionally individuals criminally. Those are all my duties. And then on the other side, they wouldn't hear, oh, the fine for speeding is $25. The sanction for breaking your promise is expectation damages. The punishment for a criminal violation is 3 years. They wouldn't hear that. They would just hear this other thing. Now, there are important reasons why they need to hear both. But if we had the acoustic separation, you could get clarity about what your actual duty is. What Oliver Wendell Holmes does in his very famous speech that becomes to the Boston University faculty and students, that becomes the path of the law, is that he ruptures that acoustic separation. And he says, no, we should look at law like a bad man. The bad man doesn't take the duty as something he should do. He says, oh, I should keep my promise or pay expectation damages. And that disjunctive becomes the duty itself. I just think that does, I don't think that's right, but that's, so my theory is that when people make an announcement, when your entitlements are announced, that's the duty. And not only that, I don't think most Americans, I don't think most people are bad men. The bad man, the Holmesian bad man is the economic rational actor. I think that we take, not always, but for some things, we take an internal point of view on the law. When we hear our duty, we follow. When our duty, when rights and duties and privileges are announced, people comport themselves with that because they take an internal point of view. And that is fundamentally law. That is fundamentally law. And what I want to persuade you about is that there is what I'm called the first law of address. It's really simple, and this is kind of this is a fun topic to talk about because we all have so much experience about it. We all know what it's like to be addressed or not be addressed. The fundamental first law of address is when somebody calls your name, or when somebody says, hey, you. There's a famous French Marxist philosopher, Louis Althusser, who talked about a policeman on the street yelling out to someone, "Hey, vous, là-bas, hey, you there," and the person turns. And Althusser develops this theory called, bizarre name, interpolation, but hailing becomes the more, that by turning, you become a subject of the state. I don't know if that's what I think. I think he's definitely right about something. I think when people call you and how they call you, there's a tendency, a great tendency to turn. There's something that happens in that turning, that acknowledgement. And then in that moment when they call and you turn, there's a rapport. It could be good rapport, it could be bad rapport, there's a rapport. And from that, economists talk about this as common knowledge. Philosophers talk about this as mutual knowledge or something like this, or common ground. There's a common ground. And trapped within that common ground, depending on the form of the address, might be an announcement about certain entitlements. If I address you, in the French, you can call someone politely vous, or more informally, tu. In German, it's sie and du. There was actually a case not long ago in Germany for a police officer referring to somebody informally as du, and they brought a claim against that person, and won. We have the same distinction in English, you and thou. Thou is the informal. We abandoned that and we leveled up. Everybody now gets the formal you. But that's not the only way we address each other. That's an important one, right? It creates the common knowledge, the common ground, the shared basis. And then sometimes, hey, you Rick. Hey, you Rick means one thing if it's coming, now that I have common knowledge, if it's coming from a friend or a colleague, if it's coming from somebody I had not known before, a telemarketer, or somebody knocking at my door, means another thing. Hey, you, mister. Hey, you, boy. All of these, hey, you, ma'am. Hey, you, whatever. All of these things, because they capture and include certain announcements of entitlements. Because it's one thing, you're entitled to call me Rick if you're revealing it's friendship, it's warmth. Might be revealing presumption. What should I do with that? What should I do with that? One thing I can do is just like argue with you. No, you don't get to do that. Or how? But we live such busy lives. We live such busy lives. We can correct, we can litigate, we could try to litigate on the street, we can try to bring an arbiter. Nobody has time for that. No one has time for that, except a few fanatics. And they're important, and we'll talk about why and what those people do. Thomas Paine was a fanatic when he sought to get rid of titles of nobility in the US and in France. He thought that Americans were just so used to bowing to royalty that you could never create an egalitarian republic of free citizens if you kept those titles. He just thought it couldn't happen. And it was his argument that led to the removal, ultimately, of the inclusion of the nobility clause in the US constitutions and many state constitutions, as well as what happened in France, when France got rid of nobility, as well as slavery, until Napoleon several years, about 10 years later, reinstated both. Thomas Paine was thinking about the ordinary average American in the colonial period. After hundreds of years and generations of bowing to nobility, how are these people going to be able to act freely in their lives if they are going to still be called on to, my lady, your lord? They're going to turn. And they could fight. They now know they're free. The revolution has been won. They know they're free, but they're also busy. They don't have time to argue with this person. You just want to get on with your day. And that's the thing. That's where I think there's a kind of the power of address. The first law of address is that when you are called, you turn. And when you turn, you create common ground. And then things go from there. The power, not the law, the power that it is, it's kind of equilibrium, soft power. Burke calls this, in a related context, writing on the French Revolution, gentle power, liberal obedience. Gentle power and liberal obedience. You just don't have time. And because of that, you just comply. You just comply. And that reaffirms the norm. That makes it easier. And for those people who resist it, now they're the fanatics. They are shunned. Why are you making such a big deal about it? Ma'am, I meant it politely. And here's the really puzzling and troubling and difficult thing. It's not about a microaggression. It's not. It's society. They're not these people who use ma'am. They're not trying to be aggressive or they're being polite and kind. And you're being picky. And both are true at the same time, which makes it so complicated. And for that reason, people, okay, got 30 seconds. People will resist the change, and people will punish people who speak up about the change. And that is yet another thing, in addition to our busy lives, that we don't have time to litigate the small stuff. The people who do litigate it get sanctioned, so it doesn't get challenged further. And in this sense, it perpetuates. It perpetuates. It's low level enough. If it were more egregious, like if it were more egregious, if people were throwing around the N-word, if people were still saying boy the way they used to say boy down, there would be more challenges. It would be corrected. And there are these moments of contestation over time where Americans were challenging being called servants and calling other people master. There were moments when boy and slave were being challenged. There were moments where real change does occur. But for the most part, it doesn't. And that's the kind of power of these low-level, not microaggressions. Sometimes they are, I get that, sometimes they are. But often we don't need the bad intent. It's just what it means to be in a society with others. And it's working through, and law supports this. It's intimately connected with law. And the first law of address, the turning, the acknowledging, the common ground, that's an announcement. In the same way, racially unenforceable restrictive covenants were an announcement of things. It didn't stop being law simply because it was no longer constitutional to enforce in a court of equity in 1948. It was still law. And you could still get damages until 1953. And even after 1953, it was still law because it was being enforced through the mechanisms of other legal institutions and other legal practices. So that's what I'm trying to get at in a sort of a basic way. Thank you very much. I'll talk in a moment.
Thank you, the Houston Law Review, for inviting me to comment today on this fascinating work by Professor Rick Brooks. Professor Brooks weaves together an astonishing set of disciplines: law, linguistics, history, game theory, to this topic of address. I very much look forward to the forthcoming book on this subject. I have two sets of comments to share, one about theory, one about law. I will begin with theory. As I read Professor Brooks in his chapters and his lecture today, he claims that there is something both distinctive and pervasive about the power of address. Distinctive meaning unlike ordinary language, the ordinary power of language. Pervasive meaning that it influences us almost every day and almost every interaction with another person. As Professor Brooks says at one point, absent address, society retreats. I am not sure I'm fully convinced. At least I still want to keep an open mind on this, but let me just push back a little bit. Start with the question of whether the influence of address is pervasive. I think that address-free communication is more common than what Professor Brooks implies. And here, remember that address is not just the fact that someone speaks in your vicinity, even where the context makes clear that that you are the intended target of their speech. That's not address. Address is more narrowly a verbal reference to the person as by a name, the person spoken to, as by a name, a title, a descriptor, or a pronoun. But so consider effective communication that occurs without such references. Example one, you buy a meal at McDonald's. You step to the cashier and say, I'd like a Big Mac, medium fries, small soda. The cashier says anything else. You say no. She states the price and hands you an empty cup for you to fill at the beverage station. You hand over cash or credit card and ask, can I get ketchup? She hands you ketchup packets. All of that is a highly coordinated exchange, and it requires no address, no term where one person uses the other person's name or title or descriptor or pronoun. Even if a term of address were used, the fact that this script can work without one makes me think that it might not be causally significant to what's going on, to how well these people coordinate their exchange. Now you might say, well, that's just commerce. Commerce is different. So consider some non-commercial interactions. When people use their phones to talk or text with someone on their contact list, each person immediately knows without a term of address who they're speaking to, who their interlocutor is. So a conversation can begin without a greeting. What's up? I'm running late. Texters can say, can arrange a meeting with a few words like the bar at 9 p.m. None of those words are a term of address. You might object, that's just non-commercial interactions between people who know each other well. So consider such interactions among strangers. In the law school, one stranger says to another, where's the dean's office? And another answers by pointing and saying, down this corridor, down this hallway, corridor to the right. No term of address. I'll just list some other possible address-free exchanges among strangers. Is this line for people with tickets? When is the bus supposed to arrive? Is this seat taken? Little help, please. Hold the elevator door. Everything okay over there? I agree that the word you commonly makes an appearance in longer conversations, but I'm not sure that the sentence would be less effective at coordinating if that term of address were dropped. The second part of my comment on the theory is this. Even if address is pervasive, I'm not sure its power is distinctive, by which I mean distinct from a general power of language. Maybe the power of words of address is just a general case of the power of words and not a special case. Professor Brooks makes the point that it is difficult to ignore being addressed. If someone uses your name, it is difficult to resist replying. But note that it is also difficult to resist replying when someone speaks to you without a term of address. If a stranger in a waiting room catches your eye and asks, is this seat taken? They speak no term of address, but it is still extraordinarily rude not to respond, to just ignore them as if they had not just asked you a question. So the power here comes from the norm requiring that you answer people who speak to you, whether or not they use a term of address. So I don't think we can allocate all of that power to the power of address. Game theory offers one explanation of the general power of language that Professor Brooks and I have both separately explored. Words can create a focal point solution to a coordination game. Consider an example without address. A tangle of people wait in line to board a plane. someone shows up and says, "Where does the line for boarding group 2 begin?" Several people say, "There," pointing. That doesn't require address. Or a new arrival doesn't even ask and steps into what others regard as the middle of the line. One of them says, "The line starts back there," and others nod. The person who discovers themselves a line breaker may move to the back of the line to avoid an unpleasant conversation to solve this hawk-dove game, all without a term of address. Even when an unequal social status does provide a way to coordinate, it's not necessary to express that unequal status using address. Consider a culture in which the young defer to the old. If the line has no one in it who appears to be over 70 years old when someone shows up who appears to be over 70, one person might notice this and say, make way," to everyone else, and everyone else makes way and lets the person who's older go to the head of the line without a term of address. Or consider a coordinating word often used in law and in social movements, the word right. A group of people is more likely to gain social power if they act collectively. And a social movement leader will seek to coordinate the behavior of individuals in the group to get them to pull in the same direction. Rights language might be helpful. The leader articulates to people what their rights are, meaning what they should insist upon, stand up for, when they should play the hawk strategy, not dove. But the powerful term right is also not a term of address. By contrast, if one is trying to show deference to signal that one is going to play the dovish strategy, not hawk, one need not use address. One could just use overly polite and even sycophantic words. One could bow, or one could just say directly that you think the other person is entitled to the matter in dispute. Aside from whether address is necessary for coordination, I also have concerns about its sufficiency. For address to signal who will play hawk and who will play dove, the address terms must be inegalitarian, implying a status difference. But address terms are often equal. Both parties might refer to the other by their first names or by their last names with the same or equal titles. Even when the titles appear to rank people in a conversation, thus offering a way of coordinating over some dispute, there's a problem of context. For example, Professor Brooks mentions in his written work how a title that usually carries insulting racial meaning, boy, can be used between intimates in an affectionate way that signals equality. The reverse is also true. Some high-status titles are used in a sarcastic and subversive way. One can deploy the title professor as one uses the nickname Poindexter. Maybe no one uses that nickname anymore, but it used to mean, like the way some people use professor, that you were sort of accusing someone of being a nerd. Even when the person is a professor, using a fancy title in an informal social setting can work as a kind of insult, implying that the target insists on having everyone recognize their exalted status. If titles can carry the opposite of the usual meaning, their ambiguity renders them less reliable for resolving coordination problems. In short, the topic of address is vast, certainly vast enough for this book that Professor Brooks is writing that I want to read, but I'm not sure if there's a distinctive power from address. Now I turn to a comment on law. The topic of titles brings me, oddly enough, to the 17th century political theorist Thomas Hobbes. In his great work, Leviathan, Hobbes famously justified the existence of the state by stressing the violent chaos that would exist in its absence. He paid enormous attention to the causes of conflict and war. One cause, he said, was the tendency of men to value themselves more than others, from which he concluded that, quote, it is necessary that there be laws of honor. To the sovereign, therefore, it belongeth also to give titles of honor, and to appoint what signs of respect in public or private meetings they shall give to one another. What's so interesting to me about this passage is how perfectly it fails to capture the American system of titles. Now, I say that Americans' social norms deeply regulate titles, and I may have just a terminological difference from Professor Brooks, because a lot of what he wants to call law, I would just say that's not law. The state isn't behind that. That's just a social norm. You know, you can have order without law. Not all law is order. Not all order is legal. So American social norms regulate titles, but American law does not require that private actors give specified titles of respect to other private actors. Indeed, the law moves mostly in the opposite direction. Two aspects of federal constitutional law bear on the issue. Section 9 of Article 1 states, no title of nobility shall be granted by the United States, and Section 10 forbids the state governments from doing the same. The framers wanted to avoid recreating the European aristocracy, so they emphatically rejected the suggestion of Hobbes. The titles of nobility clauses might still permit Congress to regulate other kinds of titles, just not nobility, as by regulating what people must be called Mr. or Ms., or titles like doctor or professor. But there is no such regulation in the common law or the statutory law. Part of the explanation is a second element of constitutional law, the First Amendment. Our doctrine of free speech protects a great deal of intentionally rude and disrespectful speech, including mistitling someone. Of course, many legal rules do have some effect on address. Law can and does regulate indirectly. For example, it might constitute the tort of defamation if the mistitling implied a statement of fact. So, for example, if refusing to use the term doctor impliedly states the person is not a licensed physician when they actually are, then maybe we could have a libel lawsuit over that. Or maybe if someone lacks an MD, using the title doctor under the right circumstances could constitute medical fraud. And I will discuss below how address might provide evidence that a defendant violated a rule of discrimination law. Courts offer a useful exception here, where I concede here the law is regulating titles of address. Professor Brooks offers some fascinating cases of judges and lawyers arguing in court about how lawyers should address witnesses in court. As far as I can tell, those cases are not determined by statute, but only at the discretion of the judge, and only in court. A parallel exception is the military world, where it can be criminal insubordination not to address a superior officer with the correct title, the correct rank. The courtroom and the military preserve a strong hierarchical structure by tightly regulating the use of titles, much as Hobbes proposed. But I still say that for civilians outside of courts, the law is mostly laissez-faire about address. In general, a person is legally free to call a doctor or a professor by her first name without a title, without incurring any legal liability. You can call a friend who excels at bankruptcy law or baseball by the sobriquet Dr. B or Professor B, even though they're not really a doctor or professor and there's no legal liability. You can go around calling everyone bro or love or Mac or buddy or by the first name of the first letter of their last name, even after they ask you not to, and for the most part, you will never run afoul of the law. But there is some legal limit to all of this, and the limit is interesting because it's another way American law is something that Hobbes could never have imagined. Rather than specify the different levels of honor each person should receive, we have laws of equality. Equal protection doctrine demands heightened scrutiny of governmental classifications of race, sex, religion, or origin. Federal, state, and local laws prohibit discrimination in jobs, housing, education, public accommodations. So while there's no statutory law directly regulating address, it is indirectly regulated by equality law. Professor Brooks showed us this in his writing on this, discussing the case of Ash v. Tyson Foods. There, the 11th Circuit ruled that the term boy, spoken on multiple occasions by a white supervisor toward black plaintiffs, both adult men, was not evidence of a discriminatory deposition. Appropriately and unanimously, the Supreme Court reversed, finding that the word boy in context could serve as sufficient evidence of racial animus. For a similar claim of gender discrimination, consider Plotke versus White. Dr. Jane Plotke sued the Army for terminating her job as a historian at Fort Leavenworth. The district court granted summary judgment for the Army, and the 10th Circuit reversed. Among the facts supporting her claim, the 10th Circuit noted this disparity in address. Quote, many of her male colleagues, at least one of whom had not achieved the same level of education as she had, referred to her as Jane while referring to other male staff members with their academic titles of doctor. One can imagine generally that it's a bad fact for a defendant in a discrimination lawsuit that agents of the defendant used titles of respect or of disrespect differently depending on race or sex or other impermissible factors. So to conclude, American law does not legally require or forbid the private use of titles, but non-discrimination law creates incentives to make titles equal. Not every part of social or economic life is regulated by non-discrimination law, but much of it is, and where it applies, we might say that the law of equality is the American law of address. Thank you.
Good afternoon. It's such a pleasure and a privilege to join you today to discuss Professor Brooks' insightful and thought-provoking and in fact, brilliant work. And first, I want to thank the Law Review, especially Madison and Sophia and Eliana and the rest of the crew for consistently cheerful excellence, which is much appreciated. Now, Professor Brooks is exploring the power of address to shape and influence our encounters with each other. Yet the role of address in human interactions is one that's so common that it often remains unnoticed. And because I hadn't spent much time or attention on this dynamic myself, I confess that I initially wondered if Professor Brooks had overstated address's power. So I undertook an experiment after I read his draft. I thought that for a while I'd try not to respond when addressed. I'd try not to stop, not to turn, not to engage. I would defy and disprove the first law of address. And I failed quickly and completely. I couldn't do it. I couldn't do it with my students and my colleagues. I couldn't do it with the clerk at the grocery store checkout counter. I couldn't do it with the receptionist at the veterinarian's office. I didn't try it with my husband. Because I love him. And I abandoned my experiment because it felt so uncomfortable, so rude and hurtful to refuse to turn, to refuse to respond, to refuse to engage when addressed. Now, I imagine that some folks might have lasted longer than I did. But on the other hand, I don't think my experience is all that much an outlier. So Professor McAdams and I started out from a point of both sharing a point of skepticism about the first law of address, and maybe we ended up in different places. In theory, we could resist or ignore address. But as a practical matter, as Professor Brooks reveals, and is confirmed by my short-lived experiment, it's not easy to resist address. And now that Professor Brooks has directed our gaze to the ubiquity and the power of address, we can see it everywhere in our encounters with each other. So I'm going to spend a few minutes elaborating on one of the most important ways in which address asserts power, as identified by Professor Brooks, the power of address to make meaning, to make a thing what it is. And I'm going to specifically discuss what I'm going to call address conflicts or address contests, where individuals or communities disagree about appropriate forms of address because they disagree about address's meaning-making. Now, as we'll see, in some address conflicts, the participants dispute whether or not address makes meaning at all, or whether it's instead relatively meaningless, no big deal. And in other address conflicts, the contestants agree that address makes meaning in deeply important ways, but they dispute the appropriate form of address because they seek to make very different meanings. So I'll start with some address conflicts involving gender-specific and gender-neutral forms of address. Consider Justice Scalia's, when he was alive, his discussion of his disagreement with his longtime co-author Brian Garner about the merit, or the lack thereof, of gender-neutral references in legal writing. Justice Scalia wrote, quote, "The use of he is the traditional, generic, unisex reference to a human being. To those of us who believe that he means, and has always meant he or she, when not referring to a male antecedent, the ritual shunning of it, the use of he, to avoid giving offense to gender neutralizers, is distracting." So Justice Scalia, and he was not alone, declined to engage the idea that gendered forms of address reflect gendered understandings of the world. Instead, he objected to gender-neutral or gender-inclusive forms of address as distracting. It's no big deal. Now, in contrast, those who contest presumptively male or other gendered forms of address, for example, those who contest the use of male pronouns when referring to folks in a group that includes both men and women or could include both men and women, those folks contest the gendered forms of address because they experience it as making meaning by embedding traditional hierarchies. So under this view, gendered forms of address and gender-inclusive forms of address make meaning. They are a big deal. Gender-inclusive forms of address challenge traditional ways of thinking by enlarging our conception about the diversities of humans who do or could occupy various roles, including positions of power. So that's an example of an address conflict where the participants disagreed about whether or not address did anything important or worthwhile. Other address conflicts, however, involve contestants who agree that address is deeply important, that it makes meaning in important ways, but they disagree about which meaning should be made, and so they disagree about the appropriate forms of an address. So let's start with the very considered and for a time deeply contested choice of Mr. President when addressing the Chief Executive and Commander-in-Chief. This was a choice made after a collective discussion where all agreed that the choice of address here was deeply important, that it communicated an important meaning, even as they disagreed about which form of address best achieved the desired meaning. So this took place in 1789 debates between the House and the Senate. This was the very first dispute between the House and the Senate, which were newly made by the Constitution. And they debated the appropriate choice of addressing the President, an office that was also newly created by the Constitution and an office that had never before existed in the history of the world. Some, like James Madison, associated titles, fancy titles, with aristocracies and nobility. And they urged a simple, unadorned title for fear that otherwise the presidency might take on a monarch's power and lack of representativeness. And recall that at this time, the Constitution imposed no term limits on the president, such that a president could serve indefinitely. Others, like John Adams, urged royal references to the president, like His Highness or His Majesty, among many others. And their aim was to shore up presidential authority so that it could withstand competing influences. Adams, for example, feared that the brand new federal government would be squashed by the pre-existing and quite powerful state governments. And other folks worried that the president would be overrun by the brand new Senate. So they advocated for exalted titles when referring to the president, to make that federal office an object of ambition for talented leaders and to elevate the federal executive's authority relative to states or to Congress. Now, ultimately, this debate was resolved through politics. The House and ultimately the Senate passed resolutions saying the way to refer to the president is this way, not through regal titles, through something simple and unadorned. Refer to the president as the president, which is the term used in the Constitution themselves. And the idea here was to describe and understand the presidency as an office that was consistent with both democracy and strength. And the idea here was that simplicity did the trick. They didn't pass a law saying you must refer to the president this way. They said this is the way we should do it. And it has stuck. Other high-stakes address conflicts are instead resolved through legal challenge, at least some of them. And sometimes, for example, an addressee, a target, a listener, asserts a statutory or a constitutional right to be addressed in a certain way. And sometimes an addressor, a speaker, asserts a First Amendment right of their own to address others as they so choose. As Professor Brooks reminds us, quote, "Address serves to regulate behavior. Here, address says less about who you are than how you ought to behave. Forms of address are not merely instances of civil or political speech. They're also terms suggesting conduct, like scripts prescribing appropriate behavior." I agree. And I also think that in certain settings, especially those where the listener, the target, the addressee, has less power than the speaker, we can understand address as more of a command than a suggestion about how to behave. In other words, to borrow a concept from legal scholar Kent Greenewalt, sometimes speech, which includes address, does something, not just says something. Think, for instance, of workers who are not free to escape or challenge the speech of their employers in many circumstances. And then think of those workers who are regularly forced to endure an onslaught of racial or sexual slurs or epithets that alter the terms and conditions of their employment. Just as it would alter the terms and conditions of employment to assign workers, because of their race or sex, offices without heat in the dead of winter, they have a different job, a more miserable job. So too, requiring workers to endure pelting by epithets and slurs, which could include forms of address, means that they have a different, worse, more miserable job. Speech does something there, and not just says something. And in those cases, anti-discrimination law recognizes that speech sometimes rises to the level of illegal discriminatory conduct. The Supreme Court, for example, has held this to be the case of speech that enables workplace discrimination. And examples include statements like "white applicants only" in a job advertisement. That's speech that does something and not just says something. It signals that job opportunities are off limits to certain folks because of their race. And the same is true of verbal harassment that rises to the level of creating a hostile environment and can include address, as both Professor McAdams in his remarks and Professor Brooks in his paper acknowledged. And I agree with Professor McAdams' observation that the law of equality is our law of address. Now, Professor Brooks tells us, convincingly in my view, that those who resist address are punished in various ways, both social and internalized. And sometimes resisting address triggers punishment by the government. Think, for instance, of Mary Hamilton, who was a Black woman who was sentenced to 5 days in jail for resisting the government's racially subordinating address. Here's what happened. In the early 1960s, an Alabama state trial judge held Ms. Hamilton in contempt of court when she refused to respond to a prosecutor's racially discriminatory address when she was testifying at trial. She refused to answer the prosecutor's questions directed to her only by her first name, Mary, rather than Ms. Hamilton. And she stated that she would only answer when addressed respectfully. In other words, when she was addressed with the courtesy titles provided white witnesses, like Miss or Mrs. or Mr. The Supreme Court reversed the contempt order and the jail sentence without explanation. All it did was cite a recent opinion in which it had held that racially segregated seating in courtrooms violated the Equal Protection Clause. So I'll suggest an explanation, the explanation that I think the court should have added. Just as non-governmental speakers' address sometimes violates statutory anti-discrimination law, as we saw in the employment context, so too, in my view, can governmental speakers' address sometimes violate the Constitution. And I proposed elsewhere that the government's speech can violate the Constitution in a small but important universe of cases. Cases where the government speech changes its target's choices or opportunities in disadvantageous ways that would violate a constitutional provision if the government accomplished those same changes through regulatory action. Think, for example, of the government's threats that silence dissenters as effectively as jailing them. Think, too, not a hypothetical, of law enforcement officers lie to a young mother they had arrested, telling her, unless you waive your rights to a lawyer and speak to us right now, the court will take your child away from you. Not true. A lie, speech, that did something and not just said something. Not all laws are enacted, as Professor Brooks and Hart remind us. With that background in mind, we return to Ms. Hamilton's case. We can see that there, the judicial system determination to enforce racially discriminatory forms of address punished and deterred Black persons' participation in the legal process, thus causing harm that violates the Equal Protection Clause. And the government's discriminatory form of address there seems unexplainable by anything other than racial animus, a motivation that can't constitute even a legitimate government interest for constitutional purposes. Ms. Hamilton resisted the government's racially discriminatory address because she understood that address to have meaning-making power. And the record doesn't tell us anything about why the prosecutor refused to honor her request for respectful address, why the trial court punished her for resisting address with a jail sentence, but it's hard not to believe that they too understood the meaning-making power of that address and deliberately sought to use address to perpetuate traditional racial hierarchies. Finally, because address is, of course, a form of speech, some address conflicts require courts to consider addressers, speakers' claim of a First Amendment right to control how they address others. We can see illustrations of these sorts of conflicts in a wide range of contemporary controversies over misgendering, which describes, for example, the deliberate use of male pronouns or names or titles to address a target whose gender identity is female. So these misgendering situations can address conflicts between the targets of misgendering, addressees, who seek control over the form of address used to refer to them, conflicts between them and speakers, who seek to control the form of address they use when addressing others. Some speakers who argue for such a right, who argue that the First Amendment protects their choice of address, dismiss their target's assertion that the use of pronouns or titles or other forms of address makes meaning in any important way. But often, the parties agree that address of this type makes meaning in important ways, while they vigorously disagree over that meaning. This is from a Sixth Circuit observation in one case. Quote, "The pleadings in this case underscore that perhaps the single thing on which the parties agree is that pronouns matter. That is true for transgender students who experience the use of preferred pronouns as a vital part of affirming their existence and experience the use of non-preferred pronouns as dehumanizing, degrading, and humiliating. It is also true for the challengers who aver that using pronouns inconsistent with a person's biological sex at birth contradicts those challengers' deeply held beliefs about the immutability of sex." So in closing, Professor Brooks's powerful insights provide us with valuable tools for recognizing and trying to make sense of address's role in our interactions with each other, and address's potential both to add value to those encounters and to inflict harm to those encounters. And I've tried to draw from his insights in thinking about address conflicts by sketching a few examples. As we've seen, address conflicts sometimes involve debates over whether address does anything meaningful at all. And sometimes address conflicts involve debates where everybody agrees something deeply important is going on, but they disagree about what meaning should be made, and thus the appropriate form of address. And address conflicts are sometimes resolved. If they are resolved, they aren't always resolved. They're sometimes resolved through social practice and design, sometimes through politics, like Mr. President, and sometimes through law. And when address conflicts are litigated, courts' resolution of those conflicts often turn on whether and when the courts understand the contested address to regulate behavior. In other words, to do something and not just say something. I'm so grateful for your attention, and I look forward to our conversation.
All right, thank you so much to our three speakers. Now is the time where we get to ask them our questions. I think we have two microphone bearers from the law review. I think I'll just disperse you to the opposite side of the room. If you have a question, raise a hand, and we'll, I guess, just sort of work from whoever's nearest to the microphone passers. As you are thinking about what you'd like to know more about from the speakers, I'll take moderator's privilege, and I'll start with a question. The questions may be best addressed in the first instance to Professor Norton, but I would be interested to hear what the other panelists think as well. So, Professor Norton, you mentioned and discussed in your discussion of Scalia and Garner the collective address of groups, which may include more than one gender, which by default we often address via a gendered, I guess, pronoun. So often we say you guys, right? When in fact not everyone in the group are male. We do this, I think, in part because while you is singular and plural, it's ambiguous and thus confusing. And so often we have you guys, maybe with bad effects of address. An interesting thing is that we in Texas have a linguistic technology that doesn't appear to have been adopted in the rest of the world that I think solves this problem. We have y'all. Y'all is unambiguous between singular and plural, and is also non-gender. An interesting thing about y'all is we have it here in Texas. I think it's used more broadly in the South. And you might think that that reflects something about our underlying attitudes towards gendered speech and gender equality. Although, Texas is not famous, at least not at the moment, for being a place where gender equality is most universally respected in the United States. Yet it and the rest of the South are the place where we have y'all. And the parts of the country where we think that gender equality is more enshrined in law and social practice are places that have declined to adopt y'all. And so I just wonder what you think that tells us either about Texas, about the South, about the North, about y'all, or about gender equality.
I love this question. And isn't address fun? I mean, once you start to think about it, it's kind of all-consuming. So I love y'all. I love you all. I think the primary value, and I grew up in Seattle. I've never lived in the South, but I grew up in Seattle. In my youth, in college and law school, I spent time with folks from Texas and Alabama and other places who use the word y'all. And so now I use it, and I'm often asked where I'm from. And I use it. The primary value of y'all is that I think it's really important for a language to have different words for the second person singular and the second person plural. You, y'all. The fact that it's gender neutral is a bonus, is a bonus. Some languages do have gendered forms of the second person. English doesn't, but that's a bonus. Actually, this is one of the things that are fun about address. I know that some folks understand guys to be gender specific, and I understand that. That's actually not how I think about it. I understand guys to be in a gender neutral way. But there's other things we can agree, and this is certainly what Scalia was engaging. We can agree that, that is a gendered form of address. And I'll just add this one other anecdote about the power of address. I went to law school at a time when my law school was about evenly divided between men and women. But it was a time when there had been and continued to be only one woman that had ever served on the Supreme Court in the 200-plus history of the Supreme Court. And I had a professor who was then and now quite a very famous constitutional scholar, and he always took care when he was offering discussions of hypothetical judges to use he and she, which is not something that I had heard anybody do before. And the fact that somebody in a position of prominence and power was doing this for at least some of us, I can't claim it was all of us, some of us it was making meaning, right? It was giving us a sense, an imagination of what the profession could look like and might look like very soon.
Any other thoughts on y'all?
I grew up in North Carolina, so I used to say y'all, and I've lived outside of the South for a long time, and I don't, and it's a good word, but I guess I don't think don't really see what's lost from not having it. I guess probably there are cases where I use more syllables because I will say to my students, if any of you have a question, to make it clear that I'm referring to the group. But a lot of times I say to my students, you, and I mean everyone, and I think in context, they know that I mean everyone. So I mean, the only time this difference in singular and plural really matters is when there could be confusion about whether there's a group of people, are you speaking to just one of the people or to the group? And often through gestures or context, it's clear which is which, and when it's not, then yes, maybe you have to use a few more syllables. You know, I would say, you, Rick, or you, Peter, rather than just saying you. So I don't know. It's a friendly word.
I mean, it seems like that's actually a serious point of disagreement between you and Professor Norton. You said the primary virtue of y'all is actually the disambiguation between the singular and plural, but
It is clearly disambiguates whether it's singular or plural. All I'm saying is, lots of things disambiguate whether it's singular or plural, and it's only a subset of cases where there's an actual chance of confusion if you say you. I mean, if I'm standing in front of a group of students and I'm saying something, the content of which sounds like it would make sense for all the students, and I say you, then there's no confusion. They know I'm speaking to all of them. They don't think I'm speaking to the person physically closest to me as you. So where the situation arises, then it does save a few syllables to say y'all, as opposed to something a little more specific. I'll just say it, like, I gave up the word, and I don't feel it as a loss.
very sad for y'all. Professor Brooks, do you have thoughts on y'all?
Yeah, three things. Address is just so familiar to all of us. Everybody, we know it. Mary Douglas, this amazing anthropologist, wrote a book on purity entitled "Purity and Dirt," purity and filth, and she was trying to talk about just how socially constructed it was. These ideas of what's filthy and what's clean, and it occurred to her because in her everyday life, her husband was quite clean, and she was just a mess. She said she just was circled like Linus with the dirt trails, and there's something like that with a dress. Here's another thing. She said the body is so common to us all. We all have a body. We're all so familiar with bodies that we take ideas about bodies and treat it like we know it, when in fact we really don't know it. There's a difference between familiarity and familiarity with the particularity, one's own body, versus what bodies are up to. And I think there's something like that it's at risk with address. We all know it. We all know what it means to be addressed politely, impolitely, kindly, with y'all, colloquially. But to really understand the implications of the way you asked, Peter, I think that's to know the meaning over time and how it's evolved. I think that's I would trust not my own judgment as an individual who's familiar with language or as a legal scholar, but like serious linguists. I think what you're describing, Richard, gets cashed out in terms of pragmatics and semantics and a lot of good historical work. And I would put dollars to donuts that you can find a dissertation on y'all done by someone in a linguistics department in the South or there. So that's the first thing. I think that I want to hesitate to overclaim about any particular meaning from any particular forms of address. The second thing, in response to just kind of following up on Professor Norton's comment about gendered address. So, and I remember, and how it closes off and opens up possibilities. So in the 80s, I can't remember this exact joke, but there was a joke. It was supposed to be like a puzzle that's just to kind of leave you baffled. A boy and his father are on a flight. The plane crashes and the man dies. They race the boy to a hospital, and the surgeon says, "I can't operate, that's my son." And everybody's supposed to be puzzled. And everybody was puzzled in the 80s, because the surgeon was a woman, and that was the point of the joke. And today we would be puzzled, in the 80s they would be puzzled if the surgeon was a man, but they were in a same-sex relationship. The way, it was funny because, what was useful about breaking people out of by using she or her, is that you started to see the possibilities that women could hold those roles. So I think it does incredibly disruptive work. And I imagine that was some of what was going on in the classroom. And then the last thing, and this I think is one is a clarification and one may be a meaningful point of disagreement from the comments from Professor McAdams. Professor McAdams suggested that the power of address is working through the custom, the politeness, the civility. That's not what I'm saying. That's not where the power comes from. The power comes from the turning. Even before you decide whether to respond politely or civilly or with irritation and anger, something happens when you turn, and that's the power. And it's distinctive. And I'll just read a little bit from Christine Korsgaard is a wonderful philosopher at Harvard, and she gave a Tanner lectures. She's given multiple ones, but this is one she gave on sources of normativity in the 90s. And she takes the claim that there's nothing. Her argument will feel like there's nothing special about address. It's just like any other words. If I call your name, I make you stop in your tracks. If you love me, I make you come running. What she's getting at is you can't proceed as you did before, at least not without some active resistance. Oh, you can proceed all right, but not just as you did before. For now, if you walk on, you will be ignoring me or slighting me. It'll probably be difficult for you. You'll have to muster a certain active resistance, a sense of rebellion. But why should I have to rebel against you? Is it because I am law to you? By calling your name, I have obligated you. I have given you a reason to stop. Korsgaard thinks what's going on there is just words itself. She's building on Wittgenstein's argument. She says, in this sense, address would not be distinctive. When she notes the power of address, it creates a normative duty by calling out your name. I've obligated you. She's actually making a broader claim about language, where she says, all I have to do is to speak words of a language you know, and in this way I can force you to think. Yeah, you can force a crazy person running around screaming will force you to think. Should I get away? What should I do? It's not strictly that. It's that when someone addresses you and you turn, by that very act of turning, somehow, even Darwall describes this as, in his theory on two concepts of respect, by turning, you've limited the set of permissible reactions. You've limited the set of permissible reactions. If you didn't turn, you could pretend you didn't hear. You could do all sorts of things, but the moment you turn, at this point, if you turn and you are not polite, if you don't respond, if you don't do that, then you're doing things that are now impermissible in some normative sense. So that's the power of it. Think of contracts. Offer is a power. It's a chain power. It creates a power of acceptance. power that you exercise, and there's entitlement, that you have the power to approach me and speak to me. That's a statement of entitlement. And then you accept, that's the turning, and that creates something. And then all sorts of things traded in contracts. All sorts of things gets traded once we have the link. But it's that what's being created is not a contract, it's rapport. And the power, the address is the offer, the turn is the acceptance, and the rapport is what creates the channel. And again, it could be good, bad, all sorts of things. So I just think that I really want to be clear. It's not civility. It's not politeness. That comes later. The power is in this capacity to basically limit the set of another person's permissible activities. And then we do have a difference about law. I don't think law is statutory. I don't think all law is enacted. I don't think all law is just what's on the books, what gets enforced by courts and the police, and the incentives it creates. I think there's more to that.
Let me respond. I mean, on the what law is, obviously law is not just what's enacted. That seems like so obviously true. I can't imagine the value of saying it because it's just legislatures that enact law, but we know that courts and executives create law and they don't enact it. So of course not all law is enacted. I do think that there is a value to distinguishing between social norms and law, which is entirely how Ellickson could write a book called Order Without Law. He was talking about social norms that it seems to me you want to call law, and then it would be law without law. I mean, it's something other than law. It's not enacted law, but it's...
Richard, just because you write a book about it doesn't make it right.
Okay. Let me just say, I agree with that way of thinking. We could debate it a long time, but I think it's very helpful to have words that refer to social order, like such as social norms or conventions, that can be distinguished from things that governments do, which I think of as law. You want to question that? That's just a disagreement, a terminological disagreement we have, which we don't have to resolve. I did want to talk about the power of the turning. First of all, my point is it's not just your name or an address. If I were in a country other than the United States and I heard someone suddenly shout words that I did not understand at all, I didn't understand, were they terms of address? No idea. It would be bizarre for me not to sort of look towards the person who's speaking, to turn towards them. That is not because it's not the power of address in the sense of the person used my name or they used, they said buddy or sir or anything like that. It's just something's happening here. I need to find out what it is. The idea that that you turn and then it's polite. I mean, it is rude not to turn. It would be rude not to turn. I think that I mean, the way you talk about it makes it sound like it's almost mystical, and I want to think more rigorous, more sort of blandly, that it's something like a habit that you learn in life, in our culture, that if someone does call your name or address you, there's a chance that what they have to say to you is something you really want to hear, like, oh, you dropped something, or, oh, don't go that way, that door's locked, or don't go that way, there's a very nasty person you don't want to interact with. And so, at least in a society where there's enough trust, then you trust that the person has, that it may be to your benefit to turn, and so you develop the habit of turning. And so like a lot of things you do unreflexively, it becomes habitual, but it's also the case that it's not universal. I think of celebrities. They definitely get rid of the habit of turning every time someone calls their name because it happens so much. And I think of people who are in situations where they have something and they, like maybe money, and they know that there are hundreds of people in the vicinity who want it and are going to address them, and people just put their head down and barrel through and ignore it. So it's just a habit which, like all habits, can be overcome, and it's not, squarely based on address. It's just based on someone is speaking, and I think they may be speaking to me, so it may be in my interest usually to find out what they're saying.
Professor Gross, I'll give you 1 minute to respond, because I do want to get some questions from the audience, but I do want to hear what you have to say.
Fast. Yeah, it doesn't have to be only, it could be other words. It could be screaming. And that was Korsgaard's point. This was the idea that linguistics is the space of language is even if you don't understand the word, you just understand that somebody is screaming, it enters you, and you respond to it. So absolutely true on that. There is something distinctive about a personal address, and I think it's wrong to, I think that it is rigorous. So there's a huge body of scientific literature now on situational awareness. There's so much that's going on in our world, every person, and always, like in terms of light and sounds, tactile odors. We literally would be overwhelmed if we let it all in. We have to screen it out. There's beginning in the 1950s, there's a field of acoustic research that developed this thing called the cocktail party effect. You all know it because you've been to cocktail parties and it's buzzy, lots of people are talking, and then you're paying attention to the person you're talking to, somebody says your name and you hear it. This particular feature is known as the own name effect within the cocktail party effect. People can capture utterances that are relevant to them in some sense, and they capture their own names. It turns out that children learn this, they begin to learn it about 9, and they master it by the time they're 3. And we keep it our entire lives, and it begins to degrade when we get with age. We hear words, but when it's a reference to us, when it's an own name, when it's something like you, we turn, even when we're busy on other channels listening to other people. There's a lot of science behind it. And it's important because it's about I think we're like embodied people, like we're embodied persons. We're not abstract, rational, floating individuals making decisions like a rational agent. We're embodied agents, and our bodies are doing a lot for the way we live in this world and our society, and the law is responding in those ways.
Thank you. Okay, I want to make sure we get some questions from the audience before we run out of time. We have about 15 minutes, so we'll try to get questions rather quickly, and then hopefully get questions or answers rather quickly as well to make sure we get to anyone who might have something to ask. So if you have a question, raise your hand. We'll have a microphone come to you, and we look forward to hearing from you.
Thank you. I kept thinking about the tools that we use to address people and whether there's a hierarchy of those tools. So a name might be close to me, and so that's more powerful, but professor might be sort of a little bit more removed, right? And pronouns, you, that sort of, so is that part of your thinking for Professor Brooks, and maybe the reaction from panelists, if there's any sort of, is there a hierarchy of the tools that we use to address people? And I kept thinking, I teach trademark law, and so I kept thinking about how trademark law is justified as a sort of a tool to avoid search costs, right? A company has a name, we protect that because it's a powerful way to refer to a company. And so I talk to my students about how a name is powerful because it's the most efficient way to refer to you. So I kept thinking about the sort of hierarchy of tools of addressing people or entities.
That's a really interesting question, and I think I don't think there's a fixed hierarchy. I think it depends on the situation. I went to a talk not long ago by Rich Devalny. He was part of the SEAL Team 6 that captured and killed Osama bin Laden, and he was talking about what happens in the field when among the team, and he came up. There's a way in which they move in and out of formal titles and address, sir, and so on, into informal names. because sometimes what the situation may call for, not deference and listening to that person, but doing something else. He calls it dynamic subordination, or more colloquially, alpha swapping. You want to flip who's the alpha. So there's a dynamic quality to any kind of hierarchy that might pre-exist or you might begin with, where it could flip as a consequence of the situation.
Good. Did we have a hand on this side as well?
Hello. Okay. My question is kind of simple, so hopefully it won't take too much time. But what, in your opinion, is like the influence of consequence when it comes to being addressed? So, like, I have a scenario to go with it if you need it, but, like, yeah. Do you want me to say the scenario for you? I can say, okay. So basically, and this is more on like a friend-on-friend manner, not really government to people. If two friends were in like 2 rooms, one was tired and was a bit lazy. The other friend was addressing the one that was tired, but the one that was tired was lazy and was ignoring being addressed. So the one who was addressing him comes into the room and was angry. Why are you not responding to me? So the lazy one, he lies. He says, I was sleeping. I didn't hear you. So there's no consequences at all in that scenario, because the one that was lazy brushed it off as he was sleeping. So in situations like where you can get away with being ignored, or where ignoring you're being addressed, do you think like people would be more willing to ignore being addressed if they could get away with it?
I think people will do more of anything that they can get away with. However, what's interesting is, notice I think there were consequences, even moral consequences, right? So now he had to lie. And this is the way in which sort of the set of normative permissible actions get impacted once it's acknowledged, or once there's even a possibility that the other person knows. Maybe he'll feel some guilt. There may not be an external consequence. It might be an internal consequence. If he's relatively well socialized, he knows that lying is bad. Maybe it's also bad ignoring a person who's calling you. So maybe this person has a high tolerance for that. But I do think that there are consequences that follow. And again, the consequences is simply and initially just the shrinking or the altering of the set of permissible actions.
Anyone else, or shall I go to our...
Sure. This is...
Oh, sorry, I meant any of the panelists, but yes, if
sorry.
no other panelists have anything to say, Dean Baines is next.
And other panelists should go.
Dean Baines, the floor is yours.
Thank you. It's really been an interesting conversation. One thing I was thinking about, I don't know if I heard any of you mention, is like sometimes there are, when you look at race and gender and age, that people are told not to respond, right? So you think of kids, don't talk to strangers. You think of women on the street with, cat calls. I mean, there are opportunities where people are taught not to respond, right? That don't respond. And I wonder how you see that. I mean, in that, because there's a fear that if you do respond, there'll be negative consequences to responding, right? And so, and how do you appraise that in this, sort of scenario that you've indicated where, that there was this engagement? I mean, some are told not to engage, right? And I think also when you think of sort of race and gender, I mean, some people will take that to heart, even as an adult. I'm not supposed to speak to this group that I don't know if I see them on the street, right? Because the stranger is not the people I think would be the strangers, the stranger that I'm not most familiar with.
Yeah, it's a terrific question. I hadn't thought about it at all, but as you were speaking, it makes me feel that those are extreme exceptions that prove the rule, right? That there are some circumstances in which folks are instructed not to respond with good reason. Other examples, like threats and stalking, right? Law enforcement will tell the targets of threats and stalking, do not respond. It's existentially dangerous to respond, which is an extreme situation that I think illustrates the fact that it's against our intuition, which is our intuition is to respond.
This makes me think of advice that you give to people about interacting with police, and the fact that the Fourth Amendment doctrine defines seizure as whether a reasonable person would feel free to go about their business, in which case it's not a seizure. And yet, this work really focuses, I meant to give this comment to Professor Brooks, although probably he's already written about it, I just haven't read that part yet. And that is, people have criticized this doctrine because it's so difficult for people who have any respect for police, as well as people who have fear of police, to be rude to the police in this way. Technically it's not just about ignoring the police. It would be about saying something like, sorry, I don't have time for you now, and keeping moving on your way. But it seems like a highly unrealistic thing, given the rudeness it is not to stop like you would for a stranger who said, what time is it? You might give them at least 3 seconds, and here you don't want to. It's also true that lawyers will often tell clients in certain situations, don't say anything, right? I'm here to represent you, and now's not a good time to talk, and yet clients sometimes have a hard time following that because they are, in a sense, addressed, and they're addressed by people who want to get them to disobey what their lawyer told them.
There's a great series of cases on whether or not there's a constitutional privilege to not respond to the police when addressed. First case that went to the court, Brown v. Texas, was in the 70s. And the cases that have followed have basically said, no, you have a privilege not to respond to the police. It's sort of intimately connected to the privilege against confession. And what's interesting, though, the courts don't think about it as politeness, and I think that's right. I don't think we respond to the police out of politeness. It's hard not to respond to the police because the police has got a gun and a badge, and they have power, and the courts recognize that. The courts recognize that. So it's coercion why we respond, not politeness. Now, that doesn't mean that there aren't ways in which community policing and actually is fostering, oh yeah, the police are here to help me, as part of my community, then there's a level of civility. But when the police approach you for a question, a knock at your door, no, that's power coming to your door. And if you respond, it's usually going to be the coercive power of the interim threat that's doing it, not what I'm calling address power, this kind of need to turn around. And I do think people are trained. You mentioned famous people, Richard, where they can train themselves not to respond. I think New Yorkers are pretty good at this too, on the subways. New Yorkers are friendly, but they can really, they know. So that happens there too.
Thank you so much. I think we have a question here in the front.
I wanted to challenge the notion of it being rude, not to turn. Because in some ways, address is a form of disempowering. A whistle toward a woman, a whistle toward members of certain race. And in a way, not turning, not responding, not reclaiming your power. Can you speak to that?
I'd say just very quick.
Yeah, I guess I just meant in the normal case, somebody says, excuse me, and then maybe a title of address. It's I think, regarded, or just says, is this seat taken? I think it's rude to simply not respond. But yeah, if the initial address is itself a breach of the social norms, then I think responding to other people's norm violations can include what would otherwise be norm violations. You might respond with words that are themselves insulting words that you normally would think politeness forbids you from using, but you might think they're justified here, or just walking away. Yeah, that makes sense.
That's a great point. Irving Goffman, in his book, Behavior in Public Spaces, talks about the presumption that somebody can come up to you and just address you. He calls it a demand for civil inattention, that you should, that's something that you have too, and you should be able to claim. Yeah, and I do, again, I think all of the politeness stuff, it all happens after. It's just this, it's a privilege. Just because somebody makes you an offer doesn't mean you have to accept it. So.
I think we have time for a quick final question right here.
I will attempt to be quick. Do you think that the overemphasizing of the importance of address could actually be counterproductive in some circumstances? I think of the example of the use of ma'am and the meaning we associate with that. Being from the South and from a military family, it's ingrained to us to use that. You go to New York and it can be an insult. You use it around certain judges in this area and it can be an insult for a completely different meaning. And to Professor Norton's point, these ambiguities and the use of this term to some in circumstances could then lead that person not to use an address for fear of being insulting or insinuating meaning. I think pronouns also nowadays, with the ambiguity in pronouns and import associated with those, could be similar. Could you touch on that?
I'll just answer very briefly. That's a great question. It's really important. Actually, in the book, I have 10 pages on ma'am. For all the reasons that you just said. It's so, with a really kind of great illustration involving an exchange between Brigadier General Walsh and Barbara Baxter when he was testifying before her, and he was politely referring to her as ma'am, and she insisted that he call her senator because of certain dynamic qualities, and also what happens in the military too. It's just as you mentioned, it's not obvious. Bringing more attention to it, whether that's good or bad. I tend to think that awareness is good, no matter what. Although awareness and bringing attention may not be the same thing.
Very briefly, I'll just say there are some words like ma'am that have this, that are inherently fraught. But I do also want to make the point that even words we think are not fraught, we think are respectful, can, with the wink of an eye and a tone, be a way of mocking somebody.
All right. With that, I'll thank you all again for being here. I'll thank the Law Review for once again organizing a wonderful Frankel lecture, and I'll most of all thank our three distinguished speakers for traveling here to Houston, to sharing their scholarship, their ideas, and their time with us. Please, round of applause again.